Hi, everyone. Welcome back from the break. My name is Ashley Baker. I'm Director of Public Policy at the Committee for Justice. I'm also the founder of our Alliance on Antitrust Coalition, which spearheads our antitrust efforts and brought to you this event. So we have two great panels lined up for you guys today following our great member panel that just ended. And I'm going to let Jim Edwards introduce the panel and panelists. Our next panel, though, is we're going to discuss agency enforcement actions and legal challenges, particularly from the end of last year through now, today, and some ongoing issues, particularly at the Federal Trade Commission, but also the Department of Justice. Jim, I'll leave it to you.
Ashley Baker is the Director of Public Policy at the Committee for Justice, and she's going to be moderating this panel, so it's my pleasure to introduce her. And she has worked on Supreme Court nominations on regulatory policy, antitrust, and judicial nominations more generally. She's written widely and is founder of the Alliance on Antitrust, which is about 24 or so conservative and center-right organizations, and again, defending the consumer welfare standard and the rule of law. She's active in the Federalist Society and the Republican National Lawyers Association. So, Ashley, welcome, and let me introduce our panelists. Jay Ezrielev is founder and managing principal at Elevecon, I believe.
Elevecon.
Elevecon, thank you. He's a former economic advisor at the Federal Trade Commissioner to Chairman Joseph Simons. Jay is has broad experience in economic analysis for antitrust matters and participated in the 2020 vertical merger guidelines. Welcome, Jay. Daniel Gilman is Senior Scholar in Competition Policy at the International Center for Law and Economics. And Daniel is an attorney, was formerly attorney advisor in the Federal Trade Commission's Office of Policy Planning. Daniel is well-schooled on competition's impact and regulation, and that is his focus, and is an expert in antitrust law and economics. So welcome, Daniel. Sean Heather is Senior Vice President, International Regulatory Affairs and Antitrust at the U.S. Chamber of Commerce. Sean is the leader of the Chamber's Center for Global Regulatory Cooperation. He's been at the Chamber in other realms as well. His focus now is, among other things, antitrust policy, and on the international front, directs policy related to data governance, which may come up in this panel as well, and cross-border data flows, artificial intelligence, cybersecurity, and those types of technologies and the regulatory environment thereof. So welcome, Sean, and here's the panel.
Thank you, Jim. So since July 2023, since July last year that we've had one of these events, I'm going to start this panel off by just kind of posing a broad question to all of the panelists, which is basically, can you give me briefly each of your highlights in terms of what's coming out of the agencies and in Congress and elsewhere, what's been going on in antitrust law and policy over the past 6 months or so, second half of last year through today, and what are your focuses? Jay.
So the big event in the latter half of 2023 was in antitrust was the FTC's case against Amazon. Finally, it's here. It seems like we've been talking about it for many years, and it's building up for a long time, ever since Lina Khan's 2017 Yale law review article. And I would say it was a little bit of a, for people who were hoping for a very robust case against Amazon, was a little bit of a letdown. The case, from my perspective, doesn't seem very strong. After all the discussion about Amazon, including Lina Khan's discussion or participation in the House Antitrust Subcommittee report, where they outline all kinds of horrible things that Amazon is doing. This is what they've come up with. It seems to me like a very weak case, and Amazon, probably champagne corks are popping at Amazon. All right, I'll have more to say about enforcement, but I'll stop there.
Okay, thank you, Jay.
Look, I think that's a good analogy. I think we've seen the FTC fill the pipeline with any number of things, but they're finding it very difficult to land planes. And so I thought I would just kind of throw out there, and I know our next panel is actually going to tell you which planes they might try to actually land this year and play that. But I think, the purpose of this discussion is to talk about what all's in the pipeline. And while they're having problems landing the planes, if they land any of these, I think it's a real problem. So we shouldn't be dismissive of the fact that just because they can start a lot of adventures that cause chaos, but they're not seeming to follow through on them, is not a reason to be dismissive of what they're trying to do. But in the policy space, I think they would say they've done a lot of different kind of eating around the edges to create uncertainty in the merger process writ large. Obviously, the HSR rule, the non-compete rule, things that were both discussed a little bit on the last panel, are certainly on our radar. There's a whole raft of things that are happening in consumer protection, some of the stuff that was being talked about up here on the last panel that was referring to what was happening at the Department of Labor. We just saw the FTC come out with Bedoya speech on independent contractors. You see, not only junk fees and franchise, but the subscription rule. There's a CARS rule. There's just a lot going on that is not directly in the antitrust space, but I think has implications for people who think more broadly about competition in the economy and how government should regulate that. In the enforcement space, obviously, we have big cases like the Amazon case or the Google case at the DOJ. There'll be more of that probably on the way, but we've seen lots of merger cases. I would say the key takeaway there is that the DOJ and the FTC have won the cases that they probably should win, that are within a standard deviation of the norm, and they've had all the cases that are crazy thrown out. I hope we can talk a little bit more about those vertical theories that they would like to see advanced and how they've been shut down by the courts. I'd like to talk a little bit more about Illumina Grail and what I think is actually a win from a policy standpoint, even though it's a huge loss for the company. But there's a lot going on that is adjacent to the competition antitrust space. So we think that this recusal question that came up on the last panel is a really important one. I disagree a little bit with what went wrong there than what was said on the last panel, but we're out there pushing for the need for internal reform at the agency on recusal policy. We also are very, very concerned about the way the DOJ and the FTC are talking to foreign regulators. We've been at the forefront of unearthing and are in ongoing litigation with the FTC about communications the FTC has with foreign agencies that seems to be as if they are reaching out proactively to try to solicit agencies abroad to help do their bidding if they can't get it done here at home. And then finally, one of the big things that popped at the end of last year, which I know these are antitrust people, but in the trade space, Lina Khan and Jonathan Cantor have now co-opted Ambassador Tai and USTR to have trade policy be remade as in the image of the neo-Brandeisian movement. And you just saw last week Ambassador Tai in Brussels with Lina Khan, with Jonathan Cantor, with Rebecca Slaughter, and with Rohit Chopra over at the CFPB, former FTC, all in Brussels for a conference on antitrust regulation and the next world order. So there is a bunch of stuff happening that is not directly in the antitrust lane, that is being driven into other corners of U.S. government policy. It has our trading partners, our closest trading partners who are most allied with us on issues, shaking their heads, going, what the hell's going on? So there's a lot of other stuff, too, that I don't know if we're going to have time to get into in the time we have. But those are some of the things that we're watching in the pipeline that have us concerned.
All righty. Too much information about me, but, Dad was a refugee, so whenever I hear New World Order, I get a little...
Next world order. I'm not sure there's a difference.
Next world order. So a few things. I want to follow up on one of the things Sean said. I like to be an optimist. I see the glass as at least 18% full. And so in terms of where the FTC is winning, number one, I do think they have had some good traditional cases. I would single out the hospital merger sector, where their efforts have largely been a continuation of enforcement efforts, decades in the making, research-based enforcement to the benefit of consumers and competition. I haven't done a deep dive on all of these. I'm not in a position to bless all the details, not that anyone's asking, but at least on the surface, some of those hospital merger cases look like good cases. I'll also say, in terms of, elsewhere, that another bright spot there is, although leadership under this administration has all but killed the competition advocacy program that was, so long lauded at the FTC, and Bilal's here certainly was running that show for a while. They have at least continued with advocacy against certificates of public advantage, which are sort of state law blessings for anti-competitive hospital transactions. They harm patients, they harm third-party payers, they harm the fisc. Not a great idea. So I'm glad to see at least that little ray of light. They have sometimes I don't necessarily agree on the facts or the complete holding, but at least they've won under traditional antitrust theories. And sometimes they've lost under traditional antitrust theories. So, for instance, you saw, I think, in Meta Within, FTC sort of crowing about the fact that the court had agreed that there was such a thing as a potential competition case. Didn't happen to think they'd made a good one, but at least there was such a thing. So there is that, and one would hope there's some learning going on. I don't think it's reflected in the new merger guidelines, certainly not reflected in the earlier Section 5 statement released by the FTC. And there, I think we pulled together some trends, so maybe we can talk about some of the cases, but, is there hostility toward the tech sector? Gee, I don't know. There were, let's see, in 23, 3.5 enforcement actions involving Amazon, a couple of consumer protection ones, the recent well-known online superstore case, right? Because people who buy batteries from an online superstore would never buy it from another kind of online store or brick and mortar. Anyway, but there's also this sort of prime dark patterns case. Prime, tremendous. It's not that hard to cancel Prime. I didn't actually do it because we want to keep Prime. My wife would yell at me, but I did look at what one has to do. It's not really that hard. There's the Amazon Alexa COPA case, Children's Online Privacy Protection case. And then there was the announcement, not quite a complaint, in the One Medical merger case where they announced both antitrust and consumer protection concerns. But at least they didn't forget about Meta in the first half of 2023. Sorry, I know we're focusing on the second half, but I think there's sort of an issue here. 3 enforcement actions in the first half of 23 launched against Meta. The Meta Within case, of course, they didn't fare very well. They also apparently want to unwind the Meta Instagram deal, which had been scrutinized before, and the commission wrote about it. And then, of course, there's that little order to show cause because there was a Facebook privacy data security action resulted in a consent order. FTC came back some years later and alleged violations of the consent order and reached a settlement. Commissioner Chopra didn't like it, although it was the largest privacy or data security or both verdict or settlement in the history of the world. There were many costly behavioral remedies built into it and a little penalty of $5 billion. So now they have an order to show cause where they want to modify it, make it more stringent. It's a little odd. Some of the allegations predate the prior settlement. You think like, well, didn't you know? I mean, they were sort of on the table. They were self-reported. Even one of the commissioners, Alvaro Bedoya, wrote a concurring statement in which he voted with them. Said, "Gee, I'm not sure there's the requisite nexus between the allegations and the remedy, but I'll vote with you anyway." And there was a big stink. Some of a former Warren staffer very publicly excoriated him, I don't know, very odd. So, concern about tech, right? Concern about vertical mergers, which we also see in the new guidelines. Not just that vertical mergers can be anti-competitive, but sort of erasing the boundary between vertical, conglomerate, and horizontal mergers, except on, I don't know what they're going to do about structural measures for them, but there's Amgen Horizon, there's Illumina Grail, there's a Meta Within, there's a Microsoft Activision, there's a whole host in what people ordinarily call the tech sector, and also in sort of the pharma area where, one's an orphan drug matter. There are already monopoly products over orphan drugs. There's sort of a strain for closure theory. Amgen was already promising to do most of what FTC asked for just on the eve of trial, sort of larded on with some odd things. I mean, they're sort of concerned about possibly blocking or impeding entry for one or two pipeline products that are not in stage 3 testing, and why this would impose sort of like decades of requirements is a little bit of a mystery. Illumina Grail, I think, the circuit said they had the wrong standard of proof, although they'd made a prima facie case. I think there are issues there we can talk about, but maybe that's enough. I think one thing to get to is the way that maybe the guidelines help us identify some trends and help us predict where they may be going, although, of course, we don't know. They have brought some very odd cases and also some normal cases. There are new staff, but there are old staff. Maybe they'll learn from the courts, and we know what the precedents say, but certainly district courts, you don't know what they're going to do in advance, and how things percolate through, we'll have to see.
Thank you, Dan. So speaking of the guidelines, that actually brings me to my first question, since we do have a lot of former agency experience on this panel, is what is particularly notable about the new merger guidelines that were just published?
Should I take that? So yes, the guidelines were a really big event in 2023, much anticipated, made a big impact. I think the initial reaction to the guidelines was very negative, and and rightly so, because the guidelines very extreme. The draft guidelines, they outline policies that the agencies would never actually take in enforcement. There was a big disconnect between what the guidelines say and what the agencies do. And I think it was clear to everybody. And some of the biggest criticism from the guidelines actually came not from Republicans, but from Democrats, people like Carl Shapiro, who excoriated the guidelines. I think that because of the pushback, there was the finalized guidelines did dial back some of the sort of more extreme elements, but they're still very extreme. And the thing that's sort of most, I would say, most relevant is how anti-merger the whole document is, anti-business. It's very hostile to mergers, but it's consistent with things that agency leadership have done and said, and other proposals. And we should talk more about that later in the panel. I it will take a lot of time right now, but how the guidelines treated the consumer welfare standards and market power. So the draft guidelines actually made no reference at all to how consumers are affected by antitrust enforcement. It was clearly a step away from the consumer welfare standard, and what came out was just a total mess. Totally unclear what the goal is, what the policies are trying to achieve, how to interpret policies. Basically, it's all structure, and then, not clear what the goal is. The finalized guidelines actually have a little bit more language that talks about things that may be interpreted as a consumer welfare standard, but it's not clear. And given what what AG Cantor and Chair Khan have said, I think overall the agencies are not on board with the consumer welfare standard, even with this mush that's in the current guidelines. The other sort of troubling issue is the whole treatment of market power. Market power was a big element of sort of a limiting principle of the 2010 horizontal merger guidelines. In the 2023 merger guidelines, it has initially had no role in the draft guidelines. In the finalized guidelines, there's a little bit more discussion about market power, but it doesn't seem to be a limiting principle. The way you read the guidelines, it seems like the agencies can bring a case where market power is not enhanced. And if that's the case, what limits antitrust enforcement?
So kind of building off of that, Sean or Dan, what strikes you as very different about these guidelines? And also, furthermore, what does this say about the enforcement priorities of the current administration?
So, look, I think Jay's right, and I think a few things. One is just to float up to the 30,000-foot level. One sort of benefit, there's always a question, what's your audience with the guidelines? These are sort of kind of guidance for industry, but also aimed at staff, and also historically have been influential with the courts. Remains to be seen whether they'll get much purchase with the courts with the new ones. But at the most basic level, look, there are lots and lots of deals proposed every year. Indeed, lots of reportable deals every year. And one thing you would like the guidelines to articulate is not necessarily an algorithm or a crank to turn, but some sort of intelligible idea how they conceive of and mean to parse the good from the bad, right? I defy anyone to find that in the new merger guidelines. Jay mentioned structural presumptions. They did a few things with structural presumptions. One is they reverted to the level for highly concentrated market, not from the 2010 guidelines, but back to the 92 guidelines. But there was more to it than that, because let's talk about what they got rid of. first of all, in several prior editions of the guidelines, we had several categories of structural presumptions, right? So at the bottom, not exactly a safe harbor, but unconcentrated markets, small changes, at least identified as mergers unlikely to raise competitive concerns, unlikely to be challenged. A middle ground, right? Higher concentration, maybe more significant change, mergers that may raise competitive concerns, right? Could, under certain facts and circumstances, lead to a second request, maybe under some facts and circumstances lead to a challenge, but not presumed harmful, certainly. Then, highest category, where under the 2010 horizontal merger guidelines, we had two sorts of presumptions. One was for highly concentrated markets on a much higher threshold than those of the new guidelines, and a change of 200 points in HHI or more. I don't know if people are antitrust people or not, but it's a measure of concentration. It's the sum of the squares of the market shares of the market participants. But so if you had 200 points or more change to a 2,500 point or more or in highly concentrated market, right? That was presumed likely to enhance market power, right? And then there was one below that for smaller changes in highly concentrated markets that might. So what do they say now? Well, they've lowered the threshold for highly concentrated markets significantly, back down to 1,800. They've bumped that 200-point change down to a 100-point change, and maybe it's rhetorical, but they use a phrase they have never used before, so far as I know, which is mergers in two categories raise a presumption of illegality, right? You know, one thing I had always understood on staff, and I did a lot of policy work, right? A lot of it wasn't merger work. I'd consult on some mergers here and there, and I got drafted to this HSR surge team for 5 months at one point. You know, as I understood it, people were trying to understand the deal, right? The whole of the deal, the implications of the deal. There'd be follow-up questions even at the screening stage. Maybe there'd be a second request, right? But it wasn't that the staff was just looking to make out the first step in the Baker-Hughes burden-shifting framework. Like, look, can we find an argument here for a prima facie case? Of course they looked for red flags. Of course they wondered whether they could make one, but they were trying to understand the deal. Here it really looks like a litigation document. They're trying to make a case, and the burden's on the other side. I mean, what else is going on? They've gotten rid of the horizontal, vertical conglomerate distinction. They responded to some criticism that they weren't recognizing any efficiencies or merger benefits in the draft guidelines. So what do? I mean, it looks pretty cosmetic. So they say, well, for instance, one could have a failing firm defense. Well, the failing firm defense is not an easy defense. It's only tenable under certain circumstances. If you have to raise a failing firm defense, you are in trouble. And then what do they say about the failing firm defense? Well, now we'll tell you what's going to make it hard. Well, everyone in antitrust knew that was hard already. So I'm not sure that's much of an allowance. They don't really consider merger benefits at all. And I think we can see that both in terms of efficiencies, things might properly consider efficiencies, and then things you think just like, what are the incentives, right? So does Amgen really have an incentive to do what they're worried about in the foreclosure, or in the Illumina Grail case, what's their incentive to foreclose when they would in fact make a lot more money by not doing what they're worried about? They're just right. I mean, lots of things can go wrong in a merger. There are lots of ways a merger can cause harm, but there's sort of no recognition that there's a to and fro, a balancing to be done. And I think that is really a fundamental issue. The other categories have dropped out. If you look for structural presumptions, there's no middle ground. There's nothing remotely akin to a safe harbor or doesn't raise concerns. I think there's, the references to methods that might be used. Some of that discussion is useful, but in the end, you can't really tell what they're going to do when. And there's sort of this overall sense that the game is to block what they can, whether it's on behalf of consumers or other market participents or labor.
As Cantor likes to call market realities. That's his favorite phrase.
Yeah. Which is a way of, right, it's like saying stuff. It's like,
Right, more vague language. Sean, do you have anything to add to that?
Yeah, very quickly, I agree with what both Jay and Dan said. I mean, the hostility to mergers is clear. If we're talking about, on average, 60 or 70 mergers that get second requests a year, there's nothing about these guidelines that talks about why we should be looking at 80 or 90 or 100 mergers. It's just all mergers are bad. There's a lot of burden shifting that's attempting to go on here. But look, I think it took them a really long time to finalize these guidelines. I think that in some ways is a sign of lack of confidence in what they put out. Two, I think, they already road tested these. While the guidelines were being drafted and thought about and agonized over, they were bringing cases that they were losing. So I'm not exactly that concerned that the courts are going to suddenly now say, well, now that we see these guidelines in writing, we're going to rethink all of this. And the hostility is fundamentally built in the president's EO on competition. If you go back and read the EO on competition, the premise is we have a problem in our economy of everything being overconcentrated. Every sector is overconcentrated, and it's been because of a lack of M&A enforcement. The reality, though, is that they're talking about industrial concentration, which economists understand the difference between that, and kind of concentration that exists in a market power context. And they're conflating the two. And the government data shows that industrial concentration in the United States is no greater today than it was 20 plus years ago. Concentration levels seem to rise and fall over time for all kinds of different factors. Sometimes highly concentrated markets can be very competitive. Sometimes very deconcentrated markets can be less than competitive. So this concentration narrative is what they're fixated on, and they've written guidelines to reach the result they would like to reach.
Can I just quickly
Yep,
add
sure.
something? So we sort of shouldn't get too distracted by the guidelines because this is not where the agencies are in enforcement. Dan talked about the audiences. So it's important to keep in mind the audiences for the guidelines. First is the staff, the courts, the market participants, and then in this round of guideline writing, both AG Cantor and Chair Khan said that it's the public that is an audience for this. So I don't know what that means because I don't know of any people who actually read the guidelines or understand them. I mean, I think this is clearly meant to be a political document that is sort of like advocacy. It's a place to shift the debate, use the guidelines as a way to move forward antitrust policy as a debating tool. I think that actually weakens guidelines as an institution. Mm-hmm. It is sort of makes them less effective. The thing that made guidelines really important over the past 40 years is that everybody bought in. It was a consensus document. And this is what made guidelines credible with the courts. The courts now see these current guidelines, as not a document that, there's no consensus even among Democrats that this is where enforcement should be or is. Certainly not, between Democrats and Republicans. And I think the expectation is when the Republicans take the White House, go the guidelines. They should. So why would the courts defer to these guidelines? And as far as the other two really important audiences, staff and market participants, practitioners, I don't think anybody thinks that this is how agencies enforce mergers. If we talk about enforcement during the Biden administration, all the cases brought during this period could have been brought under the previous guidelines, except for one, I think, which is Amgen Horizon.
Yeah.
And that one, basically Amgen Horizon called the FTC's bluff. They said, okay, go ahead, bring it, and the FTC said, well, we're not holding, a high card hand, right? They folded. So the agencies, the staff understand that they can't go anywhere with these guidelines. And as far as these structural presumptions, going to 1800 HHI and 100 HHI delta, there is no way they would actually bring a case that's close to that, what's considered to be presumed anti-competitive under these structural presumptions. This is like a company with 28% share buying another company with 2% share would be presumed anti-competitive, presumed to violate antitrust law with very little possibility of, because they basically discount deficiencies with very little possibility of defending their merger based on deficiencies. I don't think that would actually happen, and all the cases that the agencies have brought have much, much higher HHIs. So this is not, people have talked about this. These structural presumptions are more like, look what we're doing, we're getting tough on mergers, when they actually don't need these structural presumptions.
So let's move on to discussing some of the cases. I know this has been a big year, the past year, of the FTC losing a lot in court, particularly Meta Within was mentioned earlier. Amgen might as well be counted as a loss, but there's also been a number of victories, or at least as the FTC publicly announces victories for the agencies towards the end of the year. I know, Sean, you mentioned Illumina Grail. Could you discuss that case a little bit?
Yeah, so this is actually a case that predates Khan. At the time, the agency only had 4 commissioners. It enjoyed the support of all 4 commissioners, both Republican commissioners, Wilson and Phillips, both voted in favor of the complaint. This was a vertical merger where the FTC was arguing that Illumina's acquisition of Grail would foreclose future competition. Grail had this great technology that would detect cancer and would allow all kinds of possibilities in the life sciences space as a result. But Illumina provided a key input to make that cancer detection process work. So there was this concern that would somehow, that input might not be available to other future competitors to what Grail's product was. There's also some interesting stuff here about, Grail used to be wholly owned by Illumina. It was spun out by Illumina. Illumina still owned 15% of it. They had decided to bring it back in-house. So there's other things going on here. This is also the case that got the European Union agitated. Grail has no sales in the EU, so why is the European Union looking at it? They decided to bring what they call an Article 22, which had never been used before, which was, this kind of strange theory that they can bring in cases that otherwise wouldn't be brought before them. Then they accused Illumina Grail of gun jumping because they never notified the EU, but there's nothing to notify because the EU's haven't. It just gets worse and worse and worse as you peel across this onion. Lots of Capitol Hill pressure saying, look, this is a merger that has a lot of benefit to getting this technology out in the market that Grail doesn't have the scale to do in terms of cancer identification, so on and so forth, right? Lots of gamesmanship seems to be played out between the EU, which has blocked the deal, and the FTC. Watching what happened on both sides, the thing stinks to high heaven in the Chamber's opinion. But at the end of the day, when Illumina went to court finally, because they closed the case actually around the FTC and said, we'll see you in court. So the FTC was seeking to unwind the transaction. The judge essentially said the FTC was right, that there was sufficient reason to see the potential for foreclosure. And, that somewhat squares with possibly the reasons why Phillips and Wilson supported the complaint initially. But the the winner from a policy perspective, and it's a hollow win because the transaction's dead because of Europe and because time running out of the clock, is that the judge said, but FTC, you never looked at whether there was a remedy that could address your concern of foreclosure. And Illumina Grail had put on the table several things that they were willing to do for the next multiple years to ensure that that foreclosure never came about. And the judge basically said, FTC, you need to go back and analyze whether that solves your problem. And when you look at, for example, the Amgen Horizon case where they talked about here, the FTC's bluff being called, they ended up taking the deal that Amgen Horizon offered to address their concern. The judge was on one hand willing to buy the idea that perhaps there is an opportunity for foreclosure, but the judge was not willing to say you as the agency shouldn't look at potential remedies before you decide to block the whole thing. And you see, for example, over at DOJ, Cantor has been out there big time talking about how he doesn't believe in remedies, he doesn't want to support remedies, he just wants to play Caesar, thumbs up, thumbs down. Well, guess what? Our economy is pretty complicated, and merger transactions are pretty complicated. And I think a lot of merging parties know that they may have to make some adjustments to the transaction before it will finally make it through the system. But if you have agencies who basically want to just put their, fingers in their ears and say, we won't meet with you, we won't talk with you, we won't consider what remedies might be useful in addressing our concerns, it's crazy. Last thing I'd say on this is that there was actually a presidential executive order dating back to the Clinton administration that basically directs for all civil enforcement matters, it's not specific to antitrust, but all civil enforcement matters, it says that the U.S. government, in this case the DOJ and the FTC, need to find ways to settle litigation versus bring litigation. That is not the philosophy that we have today at the DOJ and FTC. If you have to block the deal, you got to block the deal. No one's going to argue with that, right? But the fact that there's not even a willingness to sit down and talk about what other alternatives there may be that prevent the future harms to competition but support pro-competitive effects that a merger will bring, those conversations are off the table with these folks.
Yeah, I think, Illumina Grail is a hard one. I have a lot of respect for Noah Phillips and Christine Wilson. I think they're very grounded people. I'm not sure why they voted for this. I think Sean is right that this is a completely tractable theory under which to bring a case, a concern about possible foreclosure. But I think, looking at the facts, it seemed to me an odd one to begin with. Illumina had a lot more to lose from foreclosure than they did to gain. I think the incentives were really stacked in that way. Sean mentioned this open offer as a remedy. Part of why FTC lost or the respect in which FTC lost is that the Fifth Circuit said, look, this open offer should have been considered the liability stage, not just the remedy stage. And because you didn't do that, you applied the wrong legal standard to it. So you have to go back and redo this. It wasn't just that there was an available remedy. This had been offered to parties, to other firms as a contractual obligation, and had in fact been signed with some third parties before the case ever went up. And so, at least with regard to some parties, it was a binding contractual obligation. It had been offered to other parties as well. In many cases, behavioral remedies are disfavored because they can be hard to monitor, they're complicated. This was a relatively straightforward contractual limitation where firms that had the wherewithal to bring products to market through the FDA approval process had every incentive to report breach of the agreement. It's not as if they couldn't afford counsel. So you have not only the possibility of FTC coming after them for violation of a consent order, but you have a lot of private parties, to the extent that they have any interest here, with a real interest in monitoring things. I just thought that on the facts, it didn't seem that worrisome a case. theory made sense, but the facts didn't look good. I think, we can talk about some odd cases. The Amazon online superstore case, sort of like, two related efforts at Frolic and Detour. One is the search through the forest for a very high market share, and then the creative endeavor of cobbling together a market definition that will fit the market share. And so it's kind of weird. Like, Target's in the online superstore market because of the range of products they sell online. Costco, which between online and brick and mortar sales sort of outsells Target, is not there because the online only component of their superstore offerings is too small. Walmart, it turns out, in the online superstore market is much smaller than Amazon, although if you just look at retail sales between online, where Walmart is also very large, and brick and mortar, where Walmart is very large, turns out Walmart sells a lot more stuff than Amazon. I'm not saying that makes Walmart a bad player or a bad entity. It's just you have this cobbling together of a market definition that seems very, very strained. And look, maybe there's data and modeling that can cash it out as some sort of significant dimension of competition. So far from the complaint, it just seems that they have these docs that roughly show, Amazon was paying attention to other large online vendors. Good for their shareholders. They're supposed to do that. There's nothing really showing that this is a distinct dimension of retail competition. Lots of things, it seems to me, are a little bit strange about this. But at least they tried to do the market definition and the market share in some way to present it to a court. I will agree with Sean, and I guess maybe somewhat with Jay. Look, there are cases that would have been brought under prior administrations. The Google case at DOJ was in fact brought under a prior administration. That too seems a little strained to me, but you can understand the case, and it's not. It wasn't something that Jonathan Cantor cooked up. It's something that was brought in the prior administration. We can talk about that case in detail if people want. Certainly Google has huge share of general search, but there's a lot more to it than that. So
could I weigh in on Illumina Grail? So first of all, the search default Google case is terrible, but we can get to that. So a couple of very notable things about Illumina Grail. I would say first thing is I think that this is a really bad outcome for consumers because the actual merger had the potential to advance healthcare quite a bit, save lives, and really make a big impact on cancer treatment. And that didn't happen, which is unfortunate. The second thing is, I think this is a case where the outcome was, the difference to the outcome was the process. I think that the FTC benefited from the administrative court process. Had this gone to federal court, directly, not as an appellate court, I think the outcome would have been different. This case was not that different from Microsoft Activision, because the commission did the fact finding, the Fifth Circuit had to defer to the commission on some of the fact finding, which I think was very faulty. So the big issue was would Illumina have an incentive to foreclose Grail's competitors or withhold its services for DNA sequencing? And I think that the arguments for the incentive for doing that are very, very questionable. I think that they didn't make the case that they had the incentive. But the Fifth Circuit, I think, deferred to the commission, which is not totally independent when it comes to judging a case that they voted for to bring forward. So the FTC benefited from that. The other thing is, I think that the remedy, whatever issue you have with potential foreclosure, the remedy should have been able to address that. So you could have had the perfect world where you do get the benefit of the Illumina Grail combination, which would have created, I think, important healthcare benefits, and address the issues of potential foreclosure, which I think they did. And I think it's only because the FTC views efficiencies in a very skeptical way, very dismissive of efficiencies, that they've decided that this case, they wouldn't even take the remedies to address whatever issues there are. So in the end, I think the outcome was bad for consumers.
Great. And you're right, too, that that's very similar to the Microsoft Activision case and Amgen as well, in which there was this open offer, and there was a remedy that was proposed, and eventually, the agency came back around to accepting that in Amgen and came back around to accepting that in Microsoft, and you see this massive waste of agency resources in the process. What would you say would be kind of if they have one, it's hard to read into this, what is their litigation strategy? Are they just trying to make it easier for them to get a preliminary injunction in federal court? Are they, is this more about Part 3 proceedings? What exactly is going on here over the past year?
I don't know that they have a litigation strategy, and I don't pretend to speak for Chair Khan, but people have talked about the fact that, unlike other heads of agencies that think about the consequences of losing and what that means for the institution and for its credibility, I do think Chair Khan is not in any way, shape, or form moved by that. To some degree, I think Cantor's in the same boat. One might cynically say that, if they lose a bunch of cases, that becomes their justification for why we need to change antitrust law and throw this back into the faces of the Congress and say, the deck is stacked against us, and so unless you change the law, what you want us to do is not going to get there. Look, obviously, legislatively, things are not happening in this Congress on antitrust, but it is moving into the states. We do see efforts to have states, not just New York, but New Jersey, Maine, Minnesota, California. There's a couple others that are now thinking about creating their own antitrust statutes at the state level that would create an entirely different standard that is being written by the folks that are bringing you the neo-brandizing movement. There's no ability to protect consumers. It's all about competitors. They've actually scrubbed out the ability to bring efficiency or pro-competitive justifications as a defense. It's even more draconian than anything you see in the European Union if these bills that are being introduced at the State House level are to pass. Some of this we're losing narrative may fuel legislative conversations either at the federal level or the state level.
Okay, so we have a couple of minutes left before Q&A. Why don't we talk a little bit more about FTC rulemaking, ranking authority, and also the new HSR rules. I know, Dan, you've written pretty extensively about that.
Sure. So, well, look, they're supposed to have HSR rules.
Right.
the revisions that they proposed, I mean, some of it's sort of bread and butter stuff. Sort of they're going to regularize, standardize electronic submissions. That makes sense. This is how most submissions were being reviewed anyway. If you can standardize it, they haven't quite done it yet. That might actually be an administrative efficiency. The thresholds, some of the stuff is, whether it's optimal or not, certainly defensible. Some of it's weird. They're requesting, for instance, a whole lot of information that's probably not captured in ordinary course documents. So it's going to be costly to gather. And it's not just going to be costly to gather in cases where the commission has decided to bring a complaint. I mean, DOJ signed on to these, right? FTC writes them, but DOJ signs on. Not just where they issue a complaint or vote to authorize issuances of a complaint, not just where there's a second request, but every firm that has to file under the HSR rules is going to have to provide this information. And there's all sorts of odd wrinkles to it. So, agency leadership has been announcing a big new interest in labor, right? So a different proposed rule is going to ban every non-compete agreement in commerce, or at least in commerce, excluding nonprofits in the United States, for every occupation, every income tranche, all conditions. It doesn't matter what's at stake, what consideration was offered. Not just it's not enforceable, but they're going to ban the existence of these things. Right. So one question you could ask is, gee, it's not a really big agency. Do they have people to look at every labor agreement in the United States? Have a couple of labor economists. I don't know if they have any labor lawyers. And I worked there for 16 years. Seems odd before we get to the major questions doctrine, before we get to a lot of other things. Well, HSR reporting, they're asking for all sorts of labor information that's not obviously relevant. So for instance, they said, well, things like OSHA violations could signal employer market power. So we want every merging party to report every, labor rule violation, whether it's OSHA, going back 5 years. I mean, it could signal market power. It could signal a lot of other things. If you go to the labor site, it turns out that, my dad was an economist. I mean, he was mostly an academic, but he was in iLab at Department of War. Like most, the top 10 OSHA violations are in highly unconcentrated industries. About half of them are in construction and things like this. I mean, if it's a signal, it's not a very good signal. Kind of looks like a fishing expedition. They're supposed to report what labor overlaps according to 6-digit Bureau of Labor Statistics occupation codes. These are not the labor market analogs of a product market, right? A few of them are. There's more than 800 of them. Lots of them are way too broad. Lots of them are way too narrow. It's not a labor product market. They cobble this together with Commerce Department commuting zones. Yeah, those are not bad proxies for some kinds of jobs, but they're poor proxies for others. So you have this proposal where they say, yeah, we know this isn't exactly a product market. We know this isn't exactly a geographic market, but, this could provide interesting signal. You just think well, this is not, I mean, the companies know where their employees work. Or this is not, most firms don't compile this stuff in this format in ordinary course, so they're going to have to go do this. It's going to be costly, and it kind of looks like you don't want to do a 6B study, and you don't want to do a 6B study not because of constraints on your 6B authority, but because there's a Paperwork Reduction Act, and because of the Paperwork Reduction Act, if you want to issue orders to more than 9 firms, you got to jump through a lot of hoops and get approval from another part of the federal government. And so you have, quite a few studies where you're smart people working on these studies, but key parts of the study design are not dictated by economic methodology so much as the Paperwork Reduction Act. Maybe that's not the best way to do it. And a lot of these things look like sort of costly fishing expeditions, very thinly justified. And it's going to be a burden on every proposed merger. Some of them are bad, but I think the agencies recognize that many of them ought not to be challenged. And the purpose of the HSR Act, this is where, see, one of these things where it actually says, right, is right, they're supposed to not unduly burden, right? It's a give and take, it's a balancing, and some of the proposed revisions just don't seem to care about that balancing at all. What's the strategy? I don't know. In some of the rulemaking, there was an advance notice of proposed rulemaking mostly on the consumer protection side. They said maybe competition for so-called commercial surveillance, which looks like, according to their description, basically every commercial use of data that could, under some description or other of personal data, be construed as personal data. That's a lot. Something like a GDPR for the United States, maybe, although they didn't draw us a map of an actual proposed rule. Again, you want to know who's going to enforce this thing, how are they going to do it. In terms of strategy, maybe you lose some cases as a way to ask Congress to redo the federal antitrust laws. I guess it's a strategy. I haven't asked Congress for legislation on my own a lot. I'm not, people up here may have a much better take on this. Doesn't seem like an obviously good strategy. Maybe some of these rules are an interesting way to ask Congress for money. Hey, hey, Dad, I bought a Porsche. Would you like to make the payments? But I honestly don't know. I mean, look, the three FTC commissioners are smart lawyers, are intelligent people. Alvaro Bedoya was for a long, not an antitrust person, but for a long time a privacy advocate and scholar. Okay, I mean, the other two commissioners, including the chair, they're smart lawyers. I mean, maybe this is a stupid little musing on my part, but I kind of wonder how much of this has to do with the fact that they never worked cases before.
Right.
I mean, it's like, okay, we have a political system. Appointments are made, appointments are ratified, but we have three FTC commissioners with, as far as I know, no antitrust case experience at all.
Well, Lina Khan, intern at the FTC.
Yeah, she was an intern for like a couple months for Rohit Chopra, and clever fellow, but again, somebody with neither a law degree nor an economics degree who had never in his life worked an antitrust investigation or antitrust case, never, right? No publications, industrial organization. I mean, yeah, she did sort of a few months sort of internship, some sort of policy advisor to him, but he was a minority commissioner at the time. They weren't bringing cases.
Okay, so we have time for about 2 questions.
Yeah. Dan, you had talked a little bit during your remarks throughout about the Microsoft, the Activision case and the Google, and you kind of alluded to sharing your thoughts. I'd love to hear what you think about those cases.
I mean, Activision was a weird sort of potential competition case in that Microsoft wasn't in the market, right? They were not buying a competitor. The theory was, hey, they're a big, rich company with lots of expertise in computer technology and even other areas of, virtual VR tech. And they have at times talked about maybe trying to develop a product. So,
Are you talking about Meta within?
oh, sorry, that's Meta Within. That's wrong. Activision is just, Activision, I think, is, with Activision, I would look at what's going on now. Is anybody happy with the state of business now? Google case, well, it turns out people like Google as a general search engine. Maybe they won't forever, right? Bing has got some AI. Other firms are using AI to develop things. But, I've used a bunch of search engines. A bunch of them are okay. I tend to go back to Google. But, we don't always use general search engines. Sometimes we use specialized ones or do other things. The defaults, how sticky are the defaults? Well, not so sticky that people who buy Windows machines from Microsoft that all have Bing pre-installed can't switch. Most of them switch, right? Europe, right? You had this, EU, they had this case that sort of carved out this special thing just for Android devices, right? And so if you buy an Android device in Europe, there's no default. Is that a good thing? Maybe for some consumers, but most consumers like the stuff to work out of the box. They like built-ins, they like defaults. If they're not too hard to change, all the better. Well, if you buy an Android device in Europe, you get a choice screen. There's 6 choices, right? They're shuffled in the order, top to bottom, on a random basis. And it turns out, at least the surveys people have done, Google ends up with a larger share of search on those devices even than they have on Apple devices in the US, right? So they're not so sticky that people can't switch if they don't have a strong preference. Some of the expert witnesses is a little weird. There's a really good behavioral scientist talking about, in my misspent youth, I did some work in, like in my 30s, did some work in behavioral neuroscience up in Bethesda. And, so this was sort of interesting to me. I actually looked at the research and I thought, this is really interesting stuff and has very, very little to do with the case. So, he's talking about things like, well, he even had a grocery. So sometimes the default is analogized to a grocery, like a slotting fee or placement fee, right? So Coke wants to be on the end cap, even though it's already the most popular thing. And there's a marketing story for this. And, as it turns out, this phenomenal amount of money Google's coughing up to Apple, for instance, yeah, it's a phenomenal amount of money, but as a percentage of revenue, it's not out of line with other marketing expenditures. So I don't know what to make of that. But he's done research sort of not in real grocery stores, but with screens, if you're flashing sort of simulations of things, that sort of the prominence of a visual display can influence the choice somewhat, and especially so if your exposure to the visual stimulus is very, very brief. Okay? Now, it's not entirely surprising, right? You get more effect if somebody just flashes something at you. And yeah, I guess the prominence of a display can affect people's behavior. I think that's kind of the whole idea of advertising, why people pay to be visible. I'm not saying you couldn't make things so hard as to unduly stack the deck, right? The Coke goes on the end cap and the Pepsi goes in the dumpster. Maybe consumers can't actually find the Pepsi, or one does or something. But, is that really the situation here? It seems like a kind of a made-up story, just like the story that they're telling both DOJ and Google and FTC and Amazon about this sort of perpetual data advantage. We know as a general matter, that there are advantages of scope and scale in various data applications. We also know that, like, they're not infinite. And so, ultimately you get diminishing returns like you do in a lot of things. And so, like, it could be, right? It could be a self-perpetuating thing, but they're just saying it could be, and we think it is. They're not actually, I would like to see somebody, maybe it's not fun to read on the Hill, but there's computational theory work that people could do to demonstrate this. There's solid research that people could do to show that this isn't just some kind of advantage that comes with a lot of other things, right? But some sort of insuperable.
Okay, so we have time for one more quick question, really quick.
Alex Reinauer, Competitive Enterprise Institute. I think this can be answered with a yes or no, so it should be pretty quick.
Great.
Do you think the agencies will, or can we expect the agencies to resume the granting of early termination if or when they ultimately finalize the new HSR rules? Or can we expect the temporary suspension to remain indefinite?
That's a no.
I would say the same. Jay, I'll just weigh in here.
I don't know if people remember the old Saturday Night Live. If you think Generalissimo Francisco Franco was temporarily dead, then yes, but no.
The answer is no. There's nothing to think about. And I would point you all to the FTC's guidance that came out about 10 days ago on what would happen if there's a shutdown. The FTC has reversed itself and has said if we have a government shutdown, we're going to close the HSR process. That's just to screw with mergers. That's the only reason they're doing that.
Yeah.
Can I
Thank
make
you
one
all.
very quick point about this?
Yes, quickly.
There are the conditions of early termination and there's weather. On the question of weather, this is not just what's good for the agencies versus what's good for the firms, right? There are agency advantages to early termination if it can be done intelligently. It marshals resources in a more effective way, and I think that's lost.
I would agree. Okay, thank you all for joining us. We're going to move on to our next panel in about 10 minutes.